That's true, but I never had Mr. Kearney blocked, ever.
And you concocted this whole thing, didn't you?
No.
Isn't it true that this was not reported to that police officer because it never happened?
No, that's not true.
What did you say to the police?
That she filed a false proof report.
You know that these folks from the O'Keefe and the McCabe's are enemies of Mr. Kearney? Who invited you to go to the Karen Reed hearings?
The family of John O'Keefe.
The whole family?
Paul O'Keefe.
Paul O'Keefe. How do you know Paul O'Keefe?
Ms. Gaetani walked in, folded a restraining order in her hand, stood up. I went outside, I found the police officer. I asked him where I should go.
Is your testimony that, I apologize, Judge, and I'm sorry, have you,
And isn't it true that every time Mr. Kearney announced he would be at a hearing after that date, you showed up?
I only went to 2 hearings.
And those were the hearings that he announced he was going to go, right?
I don't know.
I was able to access her emails, and in the emails, there were several notifications of accounts that she had created. One called Betty Booth, another one called John Smith, and another one called Joe that was used to harass you.
Are you saying that you told that officer there was a restraining order violation by Mr. Kearney? Yes or no?
We're gonna get going. The only rules of the road is fact-based. Not interested in opinions or feeling, characterization, conclusions.
So this is a motion to vacate.
Yes.
There was part of hearing which took place in January.
What's your question?
I don't feel that under the motion that's been filed, there is a hearing that follows.
We should not, you're gonna have a hearing. Any other questions? There's one witness.
Good morning, sir. Good morning. Your name's Clay West.
Gaetani, KP-A-R.
What time was it?
You
Yes, family?
I do.
And who lives?
I have 2 young children, ages 16.
What do you do?
I'm a journalist and a YouTube artist.
In a nutshell, just give Gord a brief paragraph about what those outlets are and for what was broadcasted tonight.
So I report on matters of public concern. I do a lot of investigative journalism. In particular, for the last year, I've been covering the Karen Reed case extensively. I've been interviewing witnesses, finding out things, police covering.
How did you become acquainted with the plaintiff in this matter, Susan?
She messaged me on September 4th with a picture of herself in Freetown Beach shirt. And
Here's the question, sir. We're gonna let this same rules for both. We're not looking for our, it's a nail, reason here to make a decision.
So, Mr. Kearney, we're here today based on a motion that I filed on your behalf, asserting that because of the unclean hands of the plaintiff, the restraining order should be vacated. Has Ms. Gaetani been in contact with you when the restraining order was given?
yes, she does.
What was the first instance of contact that she initiated with you, despite the fact that she's got a restraining order against suggestion?
On February 22nd, she FaceTimed me on Facebook Messenger.
What was the details?
Well, it was an attempt to call me.
Objection. What did you receive?
I received a phone call from her that I did not answer. It was 2 in the morning.
Was there a record of the call?
There was a record call.
And was that call included in the packet sent to the judge here?
Yes, it was.
In terms of the data that was issued, did it indicate anything about whether or not you had blocked her? She had blocked your objection?
Well, the documents, they're in that direction and speak for themselves.
Yes, sir. I'm asking it to explain so the court has an illumination of what it would be.
Something here.
All right. Yeah. I'm going to show you Exhibit 1 in our filing, Mrs. Kearney. Can you have a look at that and explain what data is produced by this phone call from Ms. Gaetani tendency to restrain? Objection.
So in order to contact, she would have to unblock Facebook. And that requires hitting an unblock button 3 times and then hitting the call button. You hit 4 buttons consecutively in order to call someone.
So this is something that takes a few steps. With respect to the Karen Reed matter that you referenced, had you been trying to go to court to cover that matter under the pendency of restraining?
Yes, I have.
And you explained to the court what happened with respect to you announcing online in your shows whether you were going, as compared to when Ms. Gaetani would show up or not show up.
So she had never attended a hearing before.
That wasn't the question. If you listen to the question,
The 24th, I made an announcement that I was planning on attending and was told about it on the show. I called the story about it, put it out there.
And what happened when you got to court?
I got to court, hung out outside for a bit, then went inside the courtroom and had a seat. At approximately 2 o'clock, the Judge Kearney came in. Ms. Gaetani walked in, folded a restraining order in her hand, and I immediately, without being asked by any court officer, stood up, walked outside. I went outside, I found the police officer. I asked him where I should go, and he pointed me in the direction of the registered deeds.
Next question.
You were at the reading matter to do your job and cover the case? Correction, Your Honor.
Let's move along quicker. I just get to the heart of the next question.
Yes, I was there, how it is.
After seeing her in the courtroom, being believed, did Ms. Gaetani again appear within your view in the place that you went to order?
Objection. I didn't see her.
Overruled.
Go ahead.
Nice here. Next question.
Based on your review of video later on, what were you able to learn about where she?
Court is not interested in learning things in investigation. Fact-based questions. Any others?
Well, you exited the courtroom and went to the registry. That's correct. Did that produce any sort of court case against you?
We're taking judicial notice of the fact that we just called it a few minutes ago. Next question.
After the 24th, what was the next appearance in terms of your announcement of whether or not she showed up?
For the next hearing on March 12th, I announced prior to that I would not be going because I did, just in case she showed up, I didn't want
And
to.
I'll look at explanation, sir. I'm not trying to.
Sorry.
Is listen to the question you're asked, answer it, and then just wait. Right?
Yes.
Thank you.
I'll answer another question. So you made a public announcement about going or not going?
That's correct.
What was the announcement?
That I would not be going.
And what happened with respect to whether or not Ms. Gaetani got showed up? That
She did not show up.
objection, baseless all shit.
Suspect.
Straight. Judge, are we adhering to the rules of evidence in terms of the restraining order hearing?
Well, hearsay is admissible. You just have to connect it.
After you announced that you were not going, and after the hearing in fact happened, what were you able to learn third parties about whether or not Ms. Gaetani's there?
Objection. For the asking for liable, credible.
So, for it to be admissible, it just has to be relevant. But it has to be connected to somebody. And I apologize, I'm now the one slowing this down. Conclusions and summaries don't equal hearsay. Did somebody tell you they were there and they didn't see it? In other words, it's
Wait.
okay, sure, for both of you.
Were you informed by anyone whether or not she was there?
Yes, I was informed she's not there.
By whom?
Several people.
Stand. Next question.
On the next date of the read matter, you made an announcement.
I announced that I would be attending the matter on March 20th on my show and publication.
And so you were personally present that day?
I did not end up showing up that day. I said I was going to show up.
We answered what guys did.
So you announced you were going, but you didn't in fact show up?
Correct.
And what did you learn relative to communications to people that were at the hearing, whether or not Ms. Gaetani showed up?
Answer the question.
I saw her on video there. She was there.
What about the next hearing when March 26th, David, can you make a public announcement as to that?
Yes,
And what was that?
that I would not be going.
And what did you learn through third parties that had knowledge of who was at the hearing?
So Ms. Gaetani did not show up.
So is it fair to say that she's following you to the hearings when you announced it and not going with?
Mr. Bradl, it's fair to say you can say that in your closing. These are all fact-based questions, please.
Now, did you receive any contacts from Ms. Gaetani through social media during the pendency restraint?
Yes.
Unless there's a rule. What was the first contact that you received from social media for Ms. Gaetani?
All right, happy to see.
Anytime during the pendency of restraint?
The first one was in February 22nd.
We discussed that, and then you talked about the back and forth about going to the hearing and not going to the hearing. What were some of the social media contacts that you received from Ms. Gaetani?
I received a text message from her on March 7th.
What was the contact of that?
She said that she knew that I had gone to Dedham and Medfield Police the day before to file a police report after, and that she had turned over her phone to the police, and that I was going to go back to jail
Phones off, please.
for filing a false police report.
Did you respond to that in any way?
I did not.
Why not?
because I knew it was her. I thought it was trying to trigger a district order violation.
What was the next social media contact that she initiated with respect to you?
And that's what was on March 11th.
What happened on March 11th?
She once again text messaged me with threats that I was going to be sent back to jail, and she made demands that I go on my show and apologize.
Did you respond to that?
I did not.
Was there a subsequent contact?
There was.
What was the next?
On March 18th, I received another text message from her that was conciliatory and said that
Excuse me, the court is not looking for characterization by any witness.
Just wherever it says.
March 18th, I received another text.
And what did it say?
It said that she believed now that Karen Reed was innocent, that she was donating to her legal event fund.
Were there any other social media interactions besides pre-test?
There's been a couple Twitter accounts that have been created that are active.
Wait, what do you mean when you say a Twitter account did create?
So anyone can create a Twitter account, I'll leave this email address.
Objection.
Could allow the witness to explain it.
Anyone, all you need is email address, and she's created several Twitter accounts.
Subject to cross.
So Twitter accounts have been used to harass you online.
And with respect to recent discovery from the Pomarole, have you been able to view those items and confirm that these accounts that Lee created, in fact, from her phone?
Yes, we have.
And describe how it came to possession of her phone extraction.
It was given to us by the Massachusetts State Police Detective Tully.
And in reviewing that, in terms of defending against these charges, what were you able to discover in that extraction that links Ms. Gaetani to these anonymous accounts from which you received text messages?
We were able to access all of her emails.
Excuse me, we is not what I refer to a witness. So
What were you able to?
I was able to access her emails, and in the emails there were several notifications of accounts that she had created. Twitter sends you an email when you create an account to confirm.
So in other words, there were emails that signified that she controlled the account.
Correct.
Can you explain how that showed that she controlled the account?
Well, because she received an email saying that she was the operator and creator of the account, and since that email was in her phone, that's how we knew.
All right. And what were some of the messages that you received actually from these accounts?
One of them was created on December 20th, was a Horrid Rapids account referencing you masturbating. That was created on December 20th. The second account, called the Jane account, was used to relentlessly harass me throughout the months.
Mr. Kearney, I'm going to ask you to focus on any communications after January 8th and nothing prior to that. Okay? That's sort of record. And what you've been discussing is after that date?
That was before.
Okay.
But the phone was extracted on January. So we got everything before January.
Okay. All right. And in terms of the date of the restraining order, focus on the time after the addition of the order. Right? Now, you mentioned some sort of revenge porn.
Correct.
And did that continue after the date of the restraining order in any respect?
The account was still in existence after.
I'm sure you were able to that from the extraction.
Correct.
What were some of the other post-issuance of the restraining order emails or texts or Twitters or whatever they are that you received from the account that you learned was linked to this Gaetani from the phone search?
So the loan extraction took place on January 8th, so we had everything up to January.
We answered the next question order. And since the existence of the restraining order, are there any other contacts that have been initiated to your knowledge by Ms. Gaetani under the pendency of the restraining order?
Yes.
And what were those?
There have been several Twitter accounts that she created, one called Betty Booth, another one called John Smith, and another one called Joe, that is used to harass you on social media.
And what were some of the post-restraining order contacts that you received from those accounts?
Those accounts have been posting screenshots of text messages between Ms. Gaetani and I, taken from the perspective of Ms. Gaetani, which means her comments would be on the right-hand side.
I just wanted to know what was said. I don't need an explanation.
So the accounts posted screenshots of text messages between her and I from her perspective.
What did they say?
They were embarrassing text messages that they
That's excluded.
What do you know? Can you say actually what they said rather than characterize?
They were about They were messages that showed the injection.
You say what they showed.
Facetiousness.
They were messages that showed me in distress, saying, I love you, and things of that effect.
Did you respond to any of this under the pendency of the restraining order?
No,
No.
because I think she's trying to set me up for a violation.
Now, getting back to the February 26th court hearing, were you able to ascertain or obtain either police reports that she caused to be filed with respect alleged restraining order violations by you?
Yes.
And just in a nutshell, what did they say? Or did they allege?
We do not have witnesses characterize and summarize some of these conclusions. Fact-based questions. So please.
Did you yourself report to the police what had happened on those things?
Yes.
And what did you say to the police?
That she filed a false police report. After I reported to the data police, the Medfield police, or Vacate, she recorded us having sex without my consent.
Is that true?
Yes.
Did you yell anything at her when she came out of the courthouse on February 26th?
No.
Did she say that you did?
Later on, she did.
Who?
A data police officer.
Did you and the dead police officer review the video that was taken in real time at that case?
Yes.
Did you yell anything on the video?
I did not.
After disclosure of the video that showed you didn't say anything, to your knowledge, did Ms. Gaetani go on the public record to try to change her story about whether or not you said anything to her in violation of legal authority?
The witness is not to report summaries of what the cases about. There's police reports you can offer. If you have a,
It is offered to, or
the next question, that we don't get somebody's characterization, conclusions, opinions, analysis.
now, Mr. Kearney, based on the phone extraction provided as discovery from Ms. Gaetani, were you able to ascertain some additional communications?
Yes.
Yeah, Your Honor, thank you. I have no further questions.
Cross-examination.
Yes, thank you, Judge. Good morning, Mr. Kennedy.
Good morning.
So you described a series of communications that you say were received by you from Ms. Gaetani. You testified to today, correct?
Correct.
Okay. So one of them is fair to say you said that you received a messenger call on or about February 24th at 1:47 a.m.
February 22nd.
February 22nd. Okay. Do you have a screenshot of that?
We do.
Okay. And was that on your phone, that the phone call came?
Yes, to my Facebook. So whatever account I was logged into would get the call.
Okay. Do you have a copy of the screenshot?
Yes,
Did you submit it as part of your memorandum?
we did.
Fair to say, Mr. Kearney, that on or about December 24th, you were held pursuant to bail revocation.
December 26th.
How long was that bail revocation for?
60 days.
Isn't it true that you were released on February 23rd, 2024?
That's correct.
You said that you were home sleeping on February 22nd, 2024, when you received the phone call at 1:47.
Objection, motion is strike, mischaracterizing the testimony.
No, we can clarify. Just answer this question.
I did not say that.
You said you didn't pick it up because you were sleeping.
I did not say that.
You did not say you didn't pick it up because you were
I
sleeping?
said I didn't pick it up.
Because it was 1:47 a.m.
It was 1:57 a.m.
And you had your phone with you in jail?
I did not.
Fair to say that you never ended up talking to whoever this person was, this missed call, correct?
I did not talk to her, no.
Are you familiar, Mr. Kearney, what a sock account is?
I'm familiar, correct.
Fair to say that in the past, you've created sock accounts?
I've created some sock accounts, yes.
In layman's terms, sock accounts are fake accounts that are created for the purpose of having an account that's not connected to a real person, correct?
Sometimes.
And in fact, you had told Ms. Gaetani that you've created sock accounts in the past, correct?
I have not told her that.
You yourself have created those accounts in the past.
I have created my Facebook account is called Clarence with Emerson. That's not my real name.
On February 26th, you said you were at the hearing and you saw Ms. Gaetani, correct?
Where?
On February 26th.
Please specify where are you asking did I see her?
Oh, sure. Where were you on February 26th?
I was inside the courtroom.
Okay. And you indicated at some point you saw Ms. Gaetani?
She walked into the courtroom at 2 o'clock.
So did she approach you and try to talk to you?
No.
Did you approach her and try to talk to her?
No.
You indicated that on March 7th, 11th, and 18th, you received some communications, correct?
Correct.
March 7th, you indicated that you received a text message
Yes.
What phone number was that text message received from?
I don't remember the phone number off the top of my head.
Fair to say that's not a phone number that Ms. Gaetani had?
It's a phone number that she used, it was a burner account
Right.
that she used.
When did she use that?
March 7th.
And you know this how?
Because she was sharing, the text message was sharing information that only Ms. Gaetani was privy to.
Okay, so your testimony that it was Ms. Gaetani sending you that text message is because it's based on your assumption that only she would have this information, correct?
It's not an assumption, it's an undeniable fact.
My question to you, Mr. Kearney, is that you're assuming that it is her based on the content of the text message, correct?
I know it's her because of the content of the text.
The text message on March 11th, how did that come in? What kind of communication was that?
Same way, same phone number.
Okay, and that was a text message
There's a text message.
on your phone?
Yep, from the same message, same number that texted me on March 7th.
This is the same concept here that you knew it was her based on the content of the message, right?
That's correct.
On March 18th, you indicated there was a communication.
That's correct.
What was that communication?
It was another text message from Ms. Gaetani using the same phone number.
Fair to say, Mr. Kearney, you're indicating that it's her based on the content of the message that you received.
Yes, I know it's her because of the content.
Just to go back a little bit, you indicated that you believe Ms. Gaetani created some accounts as porn revenge or along those lines.
I know she did.
I appreciate that you know that she did. Was one of them the Betty Boop account that you mentioned?
That's correct. Oh, no, that was not a pornographic account.
Okay,
But that
but,
was her account.
and was there an El Gaetani Pornhub
That she created?
that was created? Are you
I
familiar
don't know,
with-
I'm not familiar.
Did you create that account?
No.
Would it be fair to say that you were sharing a screen with your followers concerning the Betty Boop account, and you shared screenshots about that?
I don't understand the question.
Okay. Did you not share screenshots with your audience about the Betty Boop account when you were logged in that?
I don't recall that.
Objection is to relevance, Your Honor, whether he creates accounts.
He doesn't recall it anyway, so move on.
Did you create a porn account using Ms. Gaetani's photo and her 2-year-old daughter to create an account?
No, she did.
Your testimony is that, but you're familiar with what I'm referring to.
Yes,
And your testimony is that Ms. Gaetani created an account with her daughter and her as a photo on a profile. Is that correct?
it's a picture of her and daughter fully clothed, correct.
And that postings subsequent to that were pornographic.
There was no pornographic postings on that whatsoever.
Did you make a complaint that Ms. Gaetani was wiretapping you?
I did.
What was the date of incident for that?
10/19,
October 19th?
correct.
Did you testify at all about being recorded while you were having sex with Ms. Gaetani?
Objection is to relevance, Your Honor.
Yeah, not interested. Next question.
Mr. Kearney, do you believe that Ms. Gaetani is fabricating her safety concerns of you?
I did.
Objection.
Yes, sustained. Court isn't interested in people's opinions, other than in the closing.
Your social media outlet is still active, correct? And you still present shows on your social media accounts?
I do.
As part of your ongoing criminal matter, would it be fair to say that you received what's called discovery or information?
Yes,
You received information that was on my client's cell phone, correct? You received that in complete.
yes,
You received that and you received communications from the district attorney's office concerning their disclosure, did you not?
I did not know.
You didn't receive communications?
The district attorney did not communicate with me.
Okay. Communicated with your lawyer?
Yes, he has communicated with my lawyer.
And you actually posted those emails
That's correct.
on your, okay. And those emails indicate that the information that you received, which you submitted today, was sent in error, correct?
Objection is to
How does this
relevance.
help me? No, it's not a rhetorical question. How does this help the court with its decision today?
It goes to my client's state, Your Honor, why she's in fear of Mr. Kearney.
Well, that's embarrassment, which, this deals with physical safety.
I
And by the
understand.
way, the court isn't going to relitigate the current order anyway.
I understand.
So you don't have to worry about relitigating the fear issue. It only deals with if something has happened substantial between that order and today. So that's just too far afield. Next question.
Mr. Kearney, isn't it fair to say that you, as of yesterday, started posting information that you received about Ms. Gaetani with your followers and shared that information, and you indicated that you're sharing all the information that you received on her cell phone with them?
Same objection, Your Honor.
Sustained.
And Mr. Kearney, is your testimony that, I apologize, Judge, and I'm sorry, Have you made any postings recently threatening the safety of Ms. Gaetani?
Absolutely not.
Have you made postings indicating to your followers that Ms. Gaetani is causing you, as a result of her testimony, unfair prosecution?
Objection.
Could I see counsel, please?
Mr. Kearney, you're aware that one of the provisions of the restraining order indicate that you're not to share information, private information about Ms. Gaetani. Is that correct?
Objection.
Sustained.
Motion to strike.
I have no further questions, Your Honor.
Anything on redirect?
No, Your Honor.
All right, any other witnesses for you, Mr. Bradl?
No, Your Honor.
Yes, I call Ms. Gaetani to the stand. May I inquire, Your Honor?
Okay.
Was she already sworn in? Could you please introduce yourself by stating a full name and spelling?
Lindsey Gaetani, Gaetani.
And Ms. Gaetani, for the purposes of this motion, I'm going to bring your direct attention to some of the accusations that we heard here today, okay? All right. So, are you familiar with one of the indications or the allegations that you contacted Mr. Kearney by messenger? Are you familiar with that? Could you describe to the court the circumstances of that,
Which one?
of the messenger?
On the night, it was February 22nd, 1:47 in the morning, I was taking screenshots of old messages between me and Mr. Kearney because I had grand jury testimony the following day. And I was adding evidence to a block binder, printing out old text messages. And I had my phone in my hand. I dozed off for a second, must have hit the call button. I woke to a ringing, thought thinking I was getting a call, but realized that I had accidentally called Mr. Kearney.
Okay, and how many times did it ring? Do you know?
I don't know because I awoke to the ringing, so I'm sure.
Did you intend on calling Mr. Kearney?
Absolutely not.
Okay. Were you aware where he was at that point physically?
Yes,
And where was that?
he was in jail.
Okay. So let's talk about the second incident that they described here, that Mr. Kearney described here, seeing him at the courthouse on February 26th. Can you tell us what happened that day?
I was invited to attend that Karen Reed hearing by family members of the murder victim's family of the murder victim and other witnesses in the case who I had become friendly with. They asked me.
Next question.
So they asked you to appear or to come for support?
Yes.
Okay. And had you attended the hearings previous to that?
No.
Okay. Is this your first time in hearing?
Yes.
Okay. And can you tell us what happened when you attended the hearing?
When I got there, I met our group in the parking lot behind the Registry of Deeds. We all parked our cars, we met, and one of the members from our group called the victim advocate of the murder victim family and let him know that they were with a party, myself, who has a restraining order against somebody who may or may not be inside. They wanted to make them aware.
Okay. And that would have been Mr. Kearney? Okay. And what happened next?
The advocate told the woman who called that there was nothing they could do until we got inside the courthouse, but to have my restraining order in hand to show to the court officer we entered.
Okay. And what happened at the courthouse?
We walked in as a group. As we were walking in, there was a lot of protesters there, screaming obscenities, yelling things at our group when we walked in. We walked into the entrance and going through security, we saw a court officer who I then informed and had my restraining order and showed it to him.
Okay. And how long did you speak to that court officer for?
A few seconds.
Okay. And did you see Mr. Kearney at the courthouse?
Not at that point.
Okay. And at some point you see Mr. Kearney?
Yes,
When you went to the courthouse, were you looking to speak to him or have contact with him?
absolutely not.
When was the first time you saw Mr. Kearney at that day in the courthouse?
So prior to going into the courtroom, I was brought into another room with the murder victim's family and other witnesses because there were so many protesters. So we waited there until the hearing began at 2. Then the victim advocate came about us, we lined up the door to the courtroom, and it had a glass panel, and I could see Mr. Kearney sitting on the bench. He turned around and made eye contact with me and mouthed the word "fuck" and then turned back around.
Okay. And this is at the courthouse?
Yes,
Okay. Where was Mr. Kearney seated in the
to
courthouse?
the left.
And what happened after that?
I walked in, the court officer told me to have a seat over to the right. I sat down, and then maybe 2 minutes later, I saw a court officer walk up to the direction of Mr. Kearney and then he and a woman that he was with both got up and left.
Okay. Now, did you follow them out?
No.
And at some point, did you see Mr. Kearney again that day?
Yes.
All right. So tell us what happens when you see Mr. Kearney again.
After the hearing was over, our group was exiting the courthouse, walking down the steps of the Superior Court, facing the Registry of Deeds. As we were walking down, we take a right to the ramp, to go down the ramp, and I noticed Mr. Kearney standing on the steps of the Registry of Deeds across the street. We continued walking to the right down the sidewalk. So down the sidewalk.
Objection to the narrative, Your Honor.
I appreciate that, Mr. Bradl. What's your next question, Mr. Papachristos?
So you started walking on the sidewalk? Okay. And if you can just, maybe go like sentence per sentence so we can, be able to understand. So you're walking on the sidewalk on which side of the courthouse? Was it the grand jury side or the courthouse side? Or the probation side? Which side?
Side.
Okay. Is it right outside the courthouse?
Yes.
Okay. So tell me your path of travel.
So I was on the sidewalk. We were walking to get to the crosswalk to cross over so we could go to the Registry of Deeds.
Okay. And you see Mr. Kearney at that point?
Yes.
And what was he doing?
He was across the street still, but he moved from the steps, then next to a bush or a tree, and he was holding his phone up as if he were recording.
Objection as to speculation, Your Honor, as to what he was doing through this phone. Motion to strike.
So what were you able to see? Let's not assume what Mr. Kearney was doing. What were you able to see him doing with his phone?
Holding it up.
Okay. And are there videos or photos of that, Mr. Kearney doing that?
Yes.
Okay. And are any of those on his social media platforms, do you know?
Are the pictures of him?
Yeah, or the
No.
video. And who took the video of Mr. Kearney or photos of Mr. Kearney holding his phone up?
A member from the group that I was with.
Did you have any contact with him at that point?
I did not interact with him, no.
Okay. So once you saw Mr. Kearney holding the phone
Yes.
from the corner? Okay. Did he do anything else? Did you see him doing anything else?
After we crossed the street and we got to the middle between the Registry of Deeds and the District Court, I then saw Mr. Kearney to my left on the wall next in front of the Registry of Deeds,
What was he doing?
holding his phone up.
Okay. And did you have any other interaction with him at that point?
I did not interact with him, but I believe that
We answered the question.
No.
Thank you.
So, was that the complete interaction you had, Mr. Kearney, that day? What else happened?
I believe I heard him yelling liar.
Did you see him saying that?
No.
Now, what you testified here, did you report to the police?
Yes.
You heard about text messages that were sent to Mr. Kearney on March 7th, 11th, and March 18th.
Yes.
Could you tell us whether you sent any of those text messages?
No, absolutely not.
Tell us your knowledge of those text messages.
I was made aware that he was making comments on his YouTube show after the first message was sent. I don't remember the date. And he was talking about these messages, accusing me of being the person that sent them.
Did you send them?
No.
Do you know who sent them?
No.
Did you create an account or burner phone?
No.
Are you familiar with burner phones? Has Mr. Kearney used those in the past?
I don't.
Okay. Has he created sock accounts in order to send communications?
Yes.
How are you familiar with that? How do you know?
So he was logged on to.
Objection, Judge, as to relevance of him creating other accounts.
I saw him logged on to 2 of the Twitter accounts as he was doing a live show. He didn't realize he was still logged in, and he shared his screen with the audience.
What does that exactly mean? Is this in relation to the Betty Boop account and the El Gaetani porn house?
Objection, relevance to this is misdefined.
You don't think it's important, you don't need to argue. Any questions on cross? Let's go.
And what exactly was he sharing, so we understand what you mean?
He shared his screen. He was sharing tweets from the account, and he shared a screen that showed he was still logged into both of the accounts
And this was on his social media?
on his YouTube show.
What's the YouTube show that he has
We're
called?
moving on now.
Has Mr. Kearney any access to emails or social media accounts?
Objection to what Mr. Kearney's done.
Well, has to be a basis of knowledge. Next question.
You heard Mr. Kearney testify that he indicated that he accessed your emails, correct?
Yeah.
Okay. What happened with as of yesterday?
I was made aware that he was accidentally sent in error a full extraction of my.
And what happened after that information was sent out?
I object to this line of questioning. If there's some dispute that we have with the other case, that's got nothing to do with this.
I'm just looking at this request and I'm focused on that.
Okay. So, Ms. Gaetani, bringing you back to, so none of those text messages were sent by you?
No,
Do you know who sent those text messages?
I don't.
That question was asked and answered.
Then I don't have any further questions.
Wow.
Thank you, Your Honor. Good morning, Ms. Gaetani.
Morning.
So you stated here today that Mr. Kearney was violating the restraining order on February 26th, right? By yelling at you, liar, liar.
Correct.
Right. So that was what, a little bit after 2 p.m.?
I believe so.
It was a quick read hearing, surprisingly quick to everyone, and you were leaving, right?
Correct.
And a little bit after 2.
I don't know the exact time.
But it was a quick hearing, it's at 2 o'clock, so we can agree that it was shortly after 2.
Yes.
So then you go with your newfound friends back to the registry behind the parking lot behind the registry, yes?
Objection to newfound right, Judge. Sorry.
Doesn't matter.
You go with your friends back to the registry behind the parking behind the registry, right?
Correct.
So at that point, you felt that there was some vandalism that had occurred to your car, right?
There was not a great time.
And you called the police.
Yes.
Or one of your friends called the police.
One from our group called the police, sorry.
And the policeman came there not 15 minutes after you say Mr. Kearney was saying liar, liar up the street.
Correct.
And it's fair to say that you didn't say one word to that officer about this restraining order violation that you say had just happened, correct?
No.
Is it your testimony here today that you informed that officer that there was a restraining order violation by Mr. Kearney? Yes or no?
Can you repeat the question, please?
Are you saying that you told that officer there was a restraining order violation by Mr. Kearney?
About the yelling or about seeing him?
About whatever you think the restraining order violation was.
Yes.
So it's your testimony that you told that officer.
Yes.
And what did you say to him?
I told him that I believe that he had ordered the vandalism on my car. I told him that I had a restraining order against him and he was made to leave the courtroom. And then he remained outside after, and we saw him when we were passing him and walking to my car.
So since that day, you've seen the police report, right? Has nothing in there whatsoever about any restraining order violation that happened not 15 minutes earlier, does it?
No, it doesn't.
Have you contacted the policeman to correct that?
No.
Did you do anything or take any steps to correct this egregious mistake in the officer's police report?
No.
Objection.
Isn't it true that this was not reported to that police officer because it never happened?
No, that's not true.
Isn't it true that you looked at video later on and you saw for the first time that Mr. Kearney was across the street and you concocted this whole thing, didn't you?
No.
And isn't it true that when it was brought to your attention that there was video that showed that you didn't even look over in Mr. Kearney's direction, that you backed off your initial statement to the police?
Objection.
The answer's here. Move on.
To trigger these charges, didn't you
Move on, I said.
move on into another topic, Your Honor?
Yeah.
Sure.
You just covered that one.
Now, with respect to February 26th, who invited you to go to the Karen Reed hearings?
The family of this deceased officer, John,
The whole family, or was it a specific person?
specific person,
Who?
Paul O'Keefe.
Paul O'Keefe. How do you know Paul O'Keefe?
I have met many of the witnesses in the case against Mr. Kearney. We have formed a bond due to the relentless harassment by him.
So you've sort of taken up with the enemies of Mr. Kearney after ending your relationship with Mr. Kearney. Fair to say?
Objection.
Can you recharacterize your question and ask?
You become friendly with the folks from the Reed case that are enemies of Mr. Kearney.
Objection as to enemies, Your Honor, if they're...
I'd be happy to lay foundation,
You
Your
can
Honor.
say yes or no.
They're the enemies of Mr. Kearney, aren't they? They hate Mr. Kearney, right?
I can't testify to their feelings about him.
Well, based on your conversation with them,
Yeah, I'm sorry.
I'll just finish the question and counsel can have these objections. Thank you. Based on your conversations with these folks, based on your review, all of the social media, isn't it fair to say that you know that these folks from the O'Keefe and the McCabe's and all those folks are enemies of Mr. Kearney?
Objection as to form of the question, substance, and calls for speculation on her end.
She can say yes or no. We don't like the word enemy, but other than that,
How about we say antagonistic, Your Honor?
thank you.
Antagonistic to Mr. Kearney. Let's go with that.
All right, can you repeat the question?
Are those folks antagonistic to Mr. Kearney?
Sure.
And so you've taken up friendship with those folks after ending your relationship with Mr. Kearney,
Objection
correct?
asked and answered, Your Honor.
I'm just trying to get it sorted out.
The answer wishes.
Okay, thank
Next
you.
question.
And prior to February 26th, you were aware that Mr. Kearney said that he was going to go to that hearing, right?
I don't recall.
You don't recall. Well, you're very interested in all of Mr. Kearney's postings and various accounts, aren't you?
Objection.
Overruled.
Yes or no?
Am I interested in them?
Familiar with, interested, follow?
I'm familiar.
You follow them, don't you?
Not on a regular basis.
Well, let's just use an example of your affidavit where you mention that he mentions you 92 times in one of the accounts, right?
Objection, Your Honor. I believe we covered this at sidebar.
No, this is about the question about familiarity with it. So, question's admissible for that reason.
Sorry, can you repeat it?
Sure. One of your affidavits, you referenced that you've been able to figure out from looking at all of his postings that you were mentioned some 92 or thereabouts times in those postings, right?
I was able to figure out from looking at some and from another person or group of people that keep track of the accounts to log the harassment against me and notify me. Yes.
So we can agree that that's pretty good evidence that you follow Mr. Kearney's postings pretty closely, right?
Not all of them, no.
And it's your testimony here today with all of this focus and controversy, and you say there was a restraining order violation that day. It's your testimony that you can't recall whether or not you knew he was going to be there that day?
No, I didn't. I can't recall.
Okay, so you go in the courtroom, there he is, and you have your restraining order ready to go in your hand, right?
Yeah.
And you flushed him right out of there, didn't you?
Sustained.
So as a result of him seeing you, and you say that he said something, and he just got up and left, didn't he?
After I entered the courtroom and sat down.
Yeah, and it's fair to say that you went to where he was, didn't you?
Yeah.
And you went there for the express purpose and at the behest of these folks to flush Mr. Kearney out of that courtroom and stop him from covering the case. Isn't that true?
No.
You just wanted to see, you just had an interest in that particular court date, completely independent of Mr. Kearney. Is that your testimony?
I had an interest in the Karen Reed case long before I even met or spoke to Mr. Kearney.
And this was your first time at the case, wasn't it?
My first time that I went, I was supposed to go on September 15th.
So but that didn't happen?
No.
Okay, so this is your first time on the case. And you're saying I'm sorry, go ahead and answer.
It was my first time attending, yes.
Attending the case. It's just a coincidence that that's the time when Mr. Kearney said a couple days earlier, oh, I'm going to go to that case.
Objection. Coincidence.
Question's been asked and answered.
Coincidence?
Objection.
I just didn't get it just because I didn't.
Now, well, you folks characterize coincidences in your close. I'm not interested in witnesses characterizing their own testimony. Next question.
And isn't it true that every time Mr. Kearney announced he would be at a hearing after that date, you showed up?
I only went to 2 hearings.
And those were the hearings that he announced he was going to go, right?
I don't know. I had the other date that I attended was March 20th, and I didn't know whether he was going to go or not.
So it's your testimony that you had no idea that he was going to be at that hearing.
I actually knew when I left my house at 1:30, and I wasn't planning to go that day, but when I left my house at 1:30, he was already live streaming the case from his house remotely. So I knew he would not.
So it's your testimony that you left at 1:30 with no intention of going, but then ended up there at 2 o'clock?
Yes.
Where were you going?
What do you mean, where?
You left the house at 1:30 with some other intention. What
No,
was
I
that?
had no intention prior to 1:30 that I was going to attend that day.
So you jump in the car and you develop an intention to go to the hearing just half an hour later?
No.
We're just going to move on. You say that you mistakenly called Mr. Kearney on February 22nd, I'm sorry.
Yeah.
And you're saying that was like let's just encapsulate it like it was a butt dial type situation. Is that right?
I suppose.
Isn't it true that to get him unblocked, to actually make a call, you have to do 4 separate machinations on that phone to get to the point where you can in fact call him?
That's true, but I never had Mr. Kearney blocked, ever.
One moment, please, Your Honor. Well, isn't it true that you've stated anyway, that you're in such fear of Mr. Kearney that you don't wish any communication from him, and it's now your testimony that you didn't block him from calling you?
Correct.
Didn't you say in your affidavit to this court that you did in fact unblock him at some point?
My affidavit for the restraining.
For the restraining order?
I don't recall.
Well, that will speak for itself in a moment.
I remember. Sorry. I unfriended him. I said I unfriended, did not unblock him.
Sorry, just one moment. And you say that you were taking screenshots and it resulted in you mistakenly calling Mr. Kearney, is that right?
Yeah.
Isn't it true that you can take a screenshot without unblocking anyone or without calling them?
Yes, but I never had him blocked.
Thank you very much. I have nothing further.
No, Your Honor. Thank you. No, Your Honor.
I'm sorry. Thank you very much, Your Honor. So, Judge, the granting to this court under Chapter 209A of the power to issue restraining orders is a grant of equitable jurisdiction. That grant carries with it, Judge, the ability for this court, sitting in equity, to bring to the table any possible equitable consideration. And in this case, Judge, the doctrine of unclean hands applies here. This plaintiff has used this order time and again as a weapon rather than a shield. And she does not need it in any respect at all, where she goes to where Mr. Kearney is, she contacts Mr. Kearney, she lies about interactions, and she tries to trigger restraining order applications. Your Honor, this court has the advantage of hearing the prior bail revocation hearing and going through all the police reports that I have again put into evidence here, where it shows that to trigger this underlying criminal case, she went to court, and it's recorded in the police report in our exhibit, where she very emphatically says that Mr. Kearney screamed "liar, liar" across the street, and to get these charges against him. Mr. Kearney has received all of the videos. He did not do that. Videos would reflect it if he did. The officer has seen them. That report is in here as well. She lied about trying to trigger this restraining order violation. That's incredibly serious, Your Honor. She was trying to cause Mr. Kearney to go to jail for 120 days based on that lie, the demonstrated lie by video, Your Honor. This is a person who has unclean hands, dead to rights. She has no entitlement to come to this court and maintain a restraining order where it abuses the whole concept for all of those folks that really do need a restraining order. She got this order to flush Mr. Kearney out of the Reed hearings. She got this order to get him locked up out of revenge from their relationship. She's somehow taken up with all of these enemies of Mr. Kearney in the Karen Reed case to get him, and she's been enlisted by them, Your Honor, to abuse this restraining order and go to where Mr. Kearney is. It's no different than if I have a restraining order on me, I'm an auto mechanic down the street in my garage, and she shows up at my garage and I have to leave. That's exactly what's going on here. This is Mr. Kearney's workplace. This is what he does for a living. She knew he was going to be there, and she goes there. And what's worse, she makes up this phony restraining order violation case on him and tries to get him locked up. It's unspeakably evil, Your Honor. And I ask that this court today, here and now, vacate this restraining order, stand up for people who are victimized by phony restraining orders, Your Honor. That's what's going on here. The court can use the doctrine of unclean hands as an equitable consideration, and it is crystal clear at this point that this plaintiff has abused this process, has committed a fraud on this court, and has compromised any other plaintiff that legitimately wants to come before you to seek an order. So I ask, Judge, that you release Mr. Kearney from this sword of Damocles hanging over his head that shouldn't be there. Thank you very much, Your Honor.
Thank you, Your Honor. I'm not going to use this as a soapbox about my opinions about what the parties are up to, but I can tell you this, that they filed a motion to vacate, and I'm assuming based on some sort of articulable change of circumstances, which I did not see. Attorney Bradl's summation there had a lot of his own speculation and items that weren't proved. But if we break down the case, Your Honor, they allege that at least in 5 different circumstances, which consists of a messenger on Facebook message, it includes an in-person being at the courthouse, and then 3 text messages that supposedly my client had sent. So out of all those 5, let's say, instances that they articulated to the court, only one, my client frankly admitted that she had dialed by mistake. At that point, she was also aware that Mr. Kearney was not home. He was being held, so even some sort of notion that she was trying to set him up while he was in jail just doesn't jive with the facts. But for Attorney Bradl to say what he said is rather off topic, Judge, and to be quite honest, to call my client evil and her intentions are evil, but, I mean, I don't want to honor any of those statements by arguing against them. But those 5 facts here that they articulated are not substantial enough. By the way, he's got an open criminal case for witness intimidation in which he's a victim. And as of yesterday, he's still posting her personal information for all her viewers to see. I don't think Mr. Kearney understands the import of having this restraining order and abiding by these orders, Judge. And quite frankly, my client has reported certain instances. I'm not sure what the police are going to do, but they have been reported. They haven't made out a change of circumstances, Judge. They haven't made, even under the doctrine of unclean hands, I don't see a mechanism by which they're able to vacate this restraining order. And even if it did exist, they haven't met their burden. So I would ask you to continue the restraining order as it is and deny their motion to vacate. Thank you.
For the call it very shortly, of course, we're going to consider
Thank you.
the evidence, counsel argument, and I'm going to just review the law one more time.
Thank you.
Yes, Judge.
Shortly.
Thank you.
The court has reviewed the applicable case law on this because there is case law on it. And after reviewing that, I don't find there's a legal basis, there is certainly a legal justification to vacate this order. However, after reviewing the testimony, particularly given the public and secure settings of course houses across the Commonwealth, the order is going to be modified in the following way. It's going to be modified as far as the 100-yard stay-away provision of the order is going to exclude from it 50 yards from any courthouse in the Commonwealth. All right? Hearing is over.
Thank you, Your Honor.
Ma'am, if we go downstairs, if you're worried, okay, we'll copy the updated one.
Thank you, Your Honor.
Quiet, please.